because they have already filed execution case. So let the matter be taken up on 17th of February, my lord. Motion, admission. Bless.
Two liquidation to bring on record the affidavit filed yesterday.
May please your.
No, Mr. Mandal. Affidavit was filed yesterday.
Yesterday.
Yes.
And another affidavit is filed, a counter affidavit filed today.
By?
I asked.
It is not on record.
May please your lordship. I like to mention today's item number 14, my lord.
Pardon?
Item number 14, 1-4. It was fixed for hearing, but due to some personal difficulties, my lord, I sought some time, my lord. Can it be in the last part of the February, my lord?
Okay. You inform the other side?
Well, yes, consent.
Okay.
Last part.
On the appear being made by Mr. K. Authorised, learned counsel for the appellant, having not been opposed by Ms. So, learned counsel for the respondent, the matter stands adjourned to be listed on.
My lord, last part of the February, that is, let it be on 26th. 26th.
Item 10, Your Lordship. I need further instruction from my party, Your Lordship. They have filed, I have to file agenda affidavit by the IGPN. I beg to mention for 1 week time to file my.
So B.N. Gogoi, learned counsel for the petitioner, submits that he may be granted 1 week time. You inform the other side?
Yes.
With consent from the other side, press for listing the matter after a week. Where allowed, rest is list the matter after a week.
I beg to.
May I please your lordships, for listing, my lord, on order matter, my lord, in MSc appeal, my lord, on last listed on my lord 11/11/2022, my lord.
When do you
My
want?
lord, on my lord, this month, my lord, last 26th, my lord.
This month may not be possible. Possible.
Order matter, my lord. Similar 2 matters, my lord. 25th.
Take a date from him.
My lord.
Yes.
I'm mentioning for listing of MSc appeal matter.
When?
For orders on 25th.
25th.
May I please your lordship. Lordship, I beg to mention an item for listing, my lord, RSA. My lord, there is a stay petition there which needs to be considered. Actually, the appeal is admitted, my lord, but on that day it was not considered because the execution case was not filed. However, now the execution case has been filed, my lord.
What do you want?
17th month.
Okay.
Orders.
19.
19th. Okay.
With the due consent of the other side, I beg to mention item 5 and 6 of today's daily list. Actually, in this matter, Mr. P.N. Sharma has been the engaging counsel, my lord. Unfortunately, my lord, he is suffering from my lord heart issue, my lord. He has to undergo surgery. On the last occasion also we have taken, still he has not recovered, my lord. So we are my lord, hoping that he gets all right by 26th of
Yes.
26th of February. ma'am.
February.
26.
Next date, my lord.
Actually,
Okay.
BTC is
Sir,
there,
F.
right?
Learned counsel, standing counsel for the elementary education department, appearing on behalf of Mr. P.N. Sharma, learned, conducting counsel with consent from the other side, press for listing the matter on
26th.
26th of February.
Hopefully, my
Where
lord.
allowed.
No, please, Lordship. Lordship, I beg to mention item number 16 and 17, Lordship. My friend is appearing, Lordship. Mr. Endeka is having some personal difficulty today, Lordship.
Only lucky I am preparing for the respondent, Lordship. Address is there because interim order is operating in the.
Lordship may fix any date.
May prefer fix date of it. If Lordship is
Okay.
within 5th of March, Lordship.
5th of March. Okay. Mr. Gogoi, learned counsel, M. Gogoi, learned counsel for the appellant, submits that conducting counsel Mr. N. Deka has some inconvenience today.
Yes, Lord.
And as such, he pressed for listing the matter in the first week of February. Where allowed, rest shall list the matter on 5th of February. Okay.
All right.
Mr. Your name, please?
As preferred.
S. Chakraborty, learned counsel for the respondent number 1.
May you please your lordship, I beg to mention MSc appeal for listing on March, any date.
Mars.
Order.
Take a date from him. Yes.
With the consent of other side, Lordship, I beg to mention item number 19, Lord.
19.
19, Lord.
Okay. Mr.
SI and asset, Lord.
SI,
SRA Nasir.
SRA Nasir, learned counsel for the respondent number 1.
One.
With
I'm for the
consent from the
petitioner in
other
this
side.
case.
Price for listing the matter after
Lordship, it be fixed on 17 or 18 March, as I am led by the outstation council. 18 March,
18 March. Okay.
17 March. Ah, Tuesday.
Okay.
Lordship, can it be on 19? Mr. DK Mishra is appearing in this matter, so can it be on 19 or 24th?
Okay, I will take the instruction then.
Okay.
Lordship, interim is operating in this
Okay.
matter.
Interim
Let me
order pass
continue.
earlier shall continue.
Much obliged.
Maybe Lordship, for listing, matter, RSA, my lord. RSA for hearing, my lord. Lordship, this is pending matter, my lord, 2017, my lord.
When do you want?
Lordship,
When do you want?
next week, my lord,
Next week, not possible.
10 March.
Yes.
Obliged, my lord.
Can we decide on the first week of March in the date?
Okay. Take a date from him. Yes.
May I please, my lord? I beg to mention MSc appeal, Your Honor, 2022.
When?
Like admission, column.
When do you want?
April first week.
First week of April. First week of
March.
March. Correct.
Obliged.
Yes.
Back to mention, three IAs for listing on RSA 22/2012,
When?
17, Tuesday. On 19, on 20, 19.
In the same matter?
Same at 19.
Yes.
May I please, your lordship, I want to mention three MAC appeals of 2018, lordship. 2 for hearing and 1 for orders, lordship. Next,
Take a
and
date from
one,
him, but it should be in the month of March, not in the February.
okay, lordship.
Yes.
Just to mention for listing for RSA, for orders.
Yes.
Next week.
When do you want?
Anything next week.
Next week. Next week. Okay. Yes.
I beg to mention item number 18, lordship. I have taken the consent of the RSA. The contending counsel is not well, lordship, today.
You are for
Appellant, lordship.
Mr.
M. Hassan.
M. Hassan, learned counsel for the appellant. With concern from the other side. Price for listing the matter
After 3 weeks, lordship. Any
after
date.
3 weeks. As conducting counsel, Mr.
B. Sharma.
P. Sharma is indisposed of. Fair allowed, recess the matter after 3 weeks. Yes.
I beg to mention item number 15 of today's list. That will be adjourned for the date.
May I please, my lord, I am appearing for the, my lord, respondent number 1, 2, 3, 4, my lord, the claimant respondent. My lord, with all due respect, my lord, it is the 2021 matter. And my lord, there is some urgency because the claimant is, my lord, suffering from some illness. So considering that aspect, my lord, on Tuesday or Friday, my lord, or Thursday, my lord.
In which week?
My lord, next week, my lord,
Next week.
Thursday, my lord.
Ms. M. Soikia, learned counsel, appearing on behalf of Mr. Argusami, learned conducting counsel for the appellant. With concern from the other side, press for listing the matter on
19th of February.
19th of February.
24, 19 or did it? Urgency.
Get there. 19th.
My lord, obliged.
May I please, I beg to mention for listing of a CRP IO.
When?
Because the opposite party is
When do you want?
tomorrow is urgent.
Call.
My lord, this case, my lord, the main case is listed tomorrow, my lord. I filed one, my lord, application for withdrawal of the deposited money. My lord. You can come along with the main case.
May I please, lordship, I beg to mention IA civil in orders column. Lordship, kindly list the matter of 23rd February.
23rd February. Yes.
After petition.
When? Next week. Next week.
My lord, I beg to mention for listing of a IA, your lordship, for early hearing petition, your lordship. early hearing of connected MEC appeal, your lordship. It has not come, your lordship.
When do you want?
Next, any date in the next week, your lordship.
Next week?
Your lordship.
Correct.
Next week.
Item for withdrawal, item number 1.
Yes. Case is also infractions also.
In practice?
Yes,
You are for the
I am for the,
respondent. Heard Mr. D. Day,
yes, Lord.
learned counsel for the petitioner, and Miss N. Sodhuri, learned counsel for the respondent. Mr. Day, learned counsel for the petitioner, submits that this matter become infractious, and as such, the same may be closed. Accordingly, taking note of the submission of learned counsel for the petitioner, this matter stands closed.
For motion item 2.
I dispose of on withdrawal.
May I please, Lordship? This case, Lordship, petitioner is a third party in possession. But his land has been subject matter of a suit for a decree passed without making him party. Now writ has been issued in respect of his land, and he filed an application under Order 21, Rule 97, 99, 10101, reduced Section 151 CPC. Now, provision of law says that such application has to be adjudicated. Now, learned executing court, by the order is at page 97, Lordship. Without going for adjudication, fixed it for hearing on maintainability. It is today. Today, hearing on maintainability without going for its adjudication. Maintainability cannot be decided without going into merit of the case.
No, Mr. Protesto, you see, what 97 speaks?
Lordship,
What section 97
97.
speaks?
Rule 97
No, sorry,
or Order 20.
Rule 97 speaks.
Yes.
The applicant should be a decree holder.
Oh, no, this has been decided by the Supreme Court, settled that the
In
third
which
party
case?
stranger can also come under Order.
Which case?
There are many cases, Lordship.
Many cases.
I have brought decisions also on this point.
No, very recently, Supreme Court has referred the matter to a larger bench, 5-judge bench. There are conflicting decisions.
No, regarding 97, there is no conflicting decision.
Yes. You were
Which,
that Brahmadev Sodhuri case. You were relying upon Brahmadev Sodhuri.
no, thereafter also other decision also.
Right.
Pramod Chaudhary was there, prior to that also there are decisions. That which,
Now the matter is referred to the larger bench because of conflicting decisions.
otherwise,
So, you see what order is to be passed today
Lordship,
by the trial court?
on maintainability, whether my
Yes,
petition is
yes.
maintainable or not.
Yes, yes. Let it be tomorrow or on Monday?
No, I have come against this particular order only.
Maybe.
But it cannot be hard on maintainability first, because maintainability is an issue. It has to be decided in issue.
Maybe. Because this section 9, oh no, order 97, no, rule 97 provides, no, speaks about.
Decree holder, it
Decree
says
holder.
decree holder. Any
You are
person,
not the decree holder.
yes. No. There is also where the holder of a decree for the possession of immovable property or the purchaser of any such property sold in execution of decree is registered or obstructed by any person obtaining possession of the property, he may make an application to the court complaining of such resistance obstruction. And other, as Lordship said, it has been referred, but there are previous decisions which says that.
What order is to be passed today? Let it be tomorrow or Monday.
Then it will be infectious. Is Court?
It would not be. It would not be. Tomorrow you obtain instruction, no problem.
Tomorrow. That's why I
Or,
mentioned it for.
or Monday.
No, tomorrow there will be will be filed lordship because this petition is pending. We are particularly on this point, whether executing court can first hear on maintainability without adjudicating.
Definitely, definitely.
This is the only point and
No, maintainability of the petition, definitely court may fix, court may hear both the parties on the.
no, as per lordship 101, it says all the 97 and 99
Hmm.
has to be dealt with as per rule 101. And rule 101 says all questions, including questions relating to right, title, or interest in the property arising between the parties proceeding on an application under Rule 97 or Rule 99 or their representatives and relevant to the adjudication of the application shall be determined by the court dealing with application and not by a separate suit for this purpose.
Mhm.
The court shall, notwithstanding anything to the contrary, contained in any other law for the timing in force, be deemed to have jurisdiction to decide such questions.
Mr.
So all
Professor,
questions,
you say if the learned trial court decided to hear the petition.
no, he has not
that,
decided to hear the
and
petition.
decided the issue of maintainability in your favor, then
Then it will proceed. Then it will proceed, but
your petition would be infractuous.
yes, then it will be infructuous.
So let us wait and see what order is to be passed today. You inform this court by tomorrow or on Monday.
Then tomorrow, tomorrow.
Tomorrow. Okay. After hearing Mr. S.D. Purkeswar, learned counsel for the petitioner, it is provided that recess shall raise the matter tomorrow at 2 p.m.
2 p.m. Obliged.
The numbers 21 and 22.
Not
Correct.
my friend. My friend, on other side, learned advocate Kaushik Milad is not available. Can it be after some time, Milad? Let him come, Milad. Obviously.
For reference to mediation, right? Item number 3.
My lord, this case is not fit for mediation, my lord.
Who is
They-
for the respondents?
I am for the insurance appellant, my lord. It is already fixed for hearing, my lord.
Heard. Ms. L. Sharma, learned counsel for the appellant, none appears for the respondent on call. Ms. Sharma submits that this matter is not fit for referring to the mediation. Accordingly, taking note of the submission of Ms. Sharma, learned counsel for the appellant, it is provided that let's establish the matter for hearing in the first week of March,
Last week of
last week of March.
March. Obligement.
Items for admission. Item number 4.
My lord, senior counsel M.K. Chaudhary is on legs in connection with a motion matter. Can this matter be passed over for the time being, my lord?
Number 7. Partner matter.
Wait.
Last occasion, my lord, your order, my lord. Directed the specific 2/12/2025, my lord.
Mr. Dotto, you are ready?
Your lordship, during the course of deliberation, attention of this court was brought to the page number 74, wherein it is stated that graduate teacher with pay band 2 is entitled to scale pay of rupees 5,200 with grade pay 2007, and this graduate scale had been published in Assam Gazette Extraordinary March 17, 2017, and this page 74 appears to be contradictory to the stand taken by the respondent number 2, the affidavit in opposition 12/11/2025, especially to paragraph 6 to 7. In that view of the matter, Mr. Learned Standing Counsel for the Respect Secondary Department is directed to produce the relevant documents in support of the contention being made in paragraph 6 and 7 or next step, madam. My learned friend, last occasion. Taken on 9/1/2026 by order dated, my learned friend praying for instruction, my lord, to furnish copy of the page 74 directed, and I have already submitted, my lord. Page 74. And last occasion, my learned friend stated that petitioner is a intermediate. And I think that not been so. Earlier occasion also, Honorable Court specifically stated in page earlier round of litigation, my lord, page 59. Page 61, man. Your lordship got it, my lord? Page 61, Honorable.
Yes,
Court.
yes.
How however, the petitioner submitted that after completion of diploma in elementary education, he received pay band 2 with scale pay of rupees 5,200-20200 plus grade pay rupees 2,700 per month since 2012. And that said scale is equivalent to the graduate scale of pay payable to the graduate teacher serving in the Assam lower school service as per applicable for ME, MB, senior basic school teacher, and therefore he had completed 10 years service in graduate scale of pay. He was entitled for selection post of headmaster in SA Ahmed Madrasa, my lord. I am praying before lordship only, my lord. We have not, they stated that they did not allow me to appear before the selection on the basis of I have not completed 10 years from the date of on a graduate scale of pay. They stated that we are in graduate scale of pay 2016, but I am getting the graduate scale of pay from 2012, and 2016 in revised pay was given. This is reflected in my service book, my lord. And in respect of my lord, I brought in, your lordship permit me, my lord, a honorable division bench order, my lord, who are getting the middle school, my lord, who are getting the intermediate, and who are getting, my lord, please make a little that was decided by this honorable division bench. The writ appeal number 155 of 2022 by order dated 8/8/2012. This writ appeal is filed appellants being aggrieved with the order dated so and so passed by the single judge so and so, whereby learned single judge has dismissed the writ petition filed by the appellant and refused to grant relief to them, fix the appellant in the grade pay 8,700 instead of 6,800, my lord. And my lord,
last, my lord. Having heard the learned counsel for the appellants and after taking into consideration the fact that at the time of when appellants were appointed as a teacher in the upper primary school, the entry qualification for the said post was undergraduate, and admittedly, the appellants were undergraduates. In circumstances, even though they have obtained a graduate degree later on while service, they are not entitled to the grade pay which is applicable in the case of graduate teacher, my lord. Hence, we do not find merit in this. Main thing is that if in ME, MD school, those are appointed only in undergraduate at the time of appointment before whether he is qualified graduate or higher secondary pass. Those who are in graduate, they are entitled to the grade pay, my lord. My lord is graduate. My petitioner is concerned, he has, my lord, completed in BSc, my lord, in the year of 1997. My lord, page 28, my lord, in my writ petition, my lord. Page 28, he completed 3 years science graduation, my lord, from the Gauhati University, my lord. And in the year of 1997, and he was appointed 2001, my lord. And after appointment, he sent to the basic training. He completed the basic training, my lord. And after completion of a basic training, they given the time scale of pay with, my lord.
So at the time of appointment, you had graduation degree.
Yes, yes. And those who are not graduate after appointment,
They are not entitled.
not entitled. That is the honorable division bench, my lord, clarify, my lord. That's why I'm pointing before lordship, my lord. And that pay when graduate teacher 5,200, my lord. He has getting, my lord, if honorable court permit me his service book, my lord. Page 80. Page 80, my lord.
Page?
Page 80, my lord. This is the service book, my lord.
Yes.
Page 80, allowed to draw regular time scale of pay, rupees 5,200 plus grade pay rupees 2,500, and thereafter is what corrected 2,700, my lord, next, my lord. And by person to honorable, person to the order dated 6/2/2012, he getting, my lord, graduate scale of pay as per ROP 2010, my lord. And my lord, next third space, my lord, 82, page 82. Page 82. This is the opted, this is revised scale of pay with effect from 1/4/2016, my lord. They calculated me, I am graduate scale of pay from 2016, thereby I am not completed 10 years, my lord. That's why they refused to appear before the selection, my lord, selection of headmaster.
Pardon?
That, my lord, 2001/4/2016, my lord. Please make page 82. That was in revised, opted revised scale of pay was given 1/4/2016. But I am getting graduate scale of pay with effect from, my lord, 6/2/2012, my lord. And that 10 years I'm going to complete 3 times. I am coming, that is the third time, my lord. I am going to complete 10 years March, my lord. April, my lord. 2 times they refused to entertain my application on the basis of they says that you have received graduate scale of pay 2016, so thereby you are not completed 10 years. But actually, I am getting the graduate scale of pay with effect from 6/2/2012, my lord. And that's why your lordship also pointing this My lord, page 74, your lordship, my lord, last occasion, my lord. That is with effect from, my lord, page 122, your lordship, got, my lord, your page 122. Right side, top, my lord, page 122, your lordship, got it, my lord. Annexer E 122, you also got it, my lord. Right side top, my lord. Revised graduate pay approved by the government by notification number so and so dated 19/2/2011 and applicable with effect from 1/1/2011, my lord. And I was getting in 5,200, my lord, payable to second, third, fourth, fifth, sixth line, my lord. They cannot deprive, my lord. And on the other hand, their letter already I am submitted last occasion, your lordship says that, my lord, is kept in on record at the time of final hearing that day, my lord. This letter was given, my lord, last occasion, your lordship, I am submitted. This was issued by the Under Secretary to the Government of Assam, Elementary Education Department, last para, my lord. Sorry, with reference to the subject cited above, I am directed to say that all the trained and graduate assistant teacher, ME, MB, LP school, junior school, pre-primary school have not reportedly got grade pay 2,700 as per guideline of the Finance Department. You are therefore requested kindly ensure payment of revised grade pay 2,000 to all the trained and graduate assistant teacher of the ME, LP school as was granted by the Assam Service Revision of 2010 and revised by the Finance Department notification 19/2011. A death, my lord, notification 19/2011 on the basis of that way, my lord, I was getting the graduate scale of pay, my lord. This is my humble and respectful submission.
Okay. Yes, Mr. Dotto.
You done one time question that lordship that petitioner is claiming that he has been receiving graduate scale of pay since 2012 lordship, right, annexed with page 41. It is a contention of the petitioner lordship. But lordship, if I go to the annexed H lordship, page 41, if I lordship can take this home for a moment lordship, may I read lordship?
Page number?
Page number 41 lordship.
Yes.
Lordship, this is the regular with reference to the subject cited above. I have forwarded here with DDO wise and the treasury wise breakup of OBP upper primary treasury under your jurisdiction for allowing to draw prescribed scale of pay to the teachers concerned for favor of your necessary action. This letter nowhere stated that he was allowed a graduate scale of pay. Rather, what is the import? The purpose of this letter is that he was provided the scale of pay as applicable to the teacher in their prescribed scale of pay. What was the prescribed scale of pay in 2012 for the petitioner lordship? This is the crucial point. Now, lordship, just take up the questions filed by the respond number 2 lordship. Page lordship 96 onward. In the upper primary school, there are two types of teachers. One is headmaster, one is graduate teacher science, and one is the assistant teacher having some graduate degrees. So graduate teacher science and the teachers having graduate degree are two different lordship. Both teachers cannot claim the graduate teacher standard lordship. Though they are pay scale and are similar or something, but they are not a graduate teacher. This is a confusion. The page 96 of the repeating opposition. Got it. Let it from page 98, paragraph 4 onwards. For clarification of the matter. That's a narrative. Then after going through the contention and environment made in the respective paragraph of the repetition, it is transpired that petitioner initiated the instant repetition, seeking direction to set aside and was the order dated 18/11/2020, and Act 18 of repetition. Whereby claim of the petitioner objectors regarding non-inclusion of his name in the gradation list eligible teachers for promotion to the vacant post of headmaster in high school of Sunitpur and Vishwanath district as on 1/1/2021, prepared and published by the Office of the Inspector of School, Sunitpur District Circle, was not considered and rejected, and to declare the date of receipt of graduate scale of pay of the petitioner as 6/2/2012 instead of 1/4/2015, including for promotion of the petitioner to the vacant post of headmaster in high school of Sunitpur and Vishwanath district also. Such a may I pause for a moment, Lordship. For the post of headmaster is the promotional post under rule 14 of the 2018 rule. And for to become to promote one to a headmaster, one should be a graduate teacher of 10 years experience also. Also, in purchase of the Honorable Court Order dated 39/2024 and 25/10/25, deponent begged to submit that as per report of Inspector of School, Tezpur, the petitioner was initially appointed as an assistant teacher in A.K. Ahmed M.E. Madrasa, Vishwanath, by order under memo number 12 on a fixed pay of 2,000 per month by the then district elementary education officer Sunitpur against post created by government letter dated so and so. Subsequently, his post was regularized by government order under memo number dated 21/10/2010, Annexure 5. Thereafter, the petitioner completed diploma in elementary education (DLA) course from Diet Vishwanath, and he was allowed to draw prescribed scale of pay by the district elementary education officer Sunitpur by a letter dated 6/2/2012, Annexure repetition. Thereafter, the petitioner was drawing regular pay and allowances in payment to 5/2/002 20,200 with base pay of rupees 2,700 in 31/7/2016. If proceed now, if I go to that revision of payroll lordship, as per the revision of payroll lordship, in treatment table lordship 9 lordship,
Yes. Page number?
about 153.
Sir, look.
No? Oh, 153.
Already referred to.
Videos.
I'll go to Assam Royal School Service Teaching and Inspection ME Senior Basic School. Does you got it that table? One, headmaster ME Senior Basic School. Lordship, the scale of pay lordship, 3580/90, lordship, got it, lordship? With payment, column to payment to 5000 20 200 2800. Next lordship, graduate teacher within bracket science. At the same scale of pay, and it was fixed at payment to lordship, 5200 20 200 and 2800.
Graduate skill
एक मिनट
teacher,
जरा
science teacher ना.
एक मिनट लोग 2800 the get pay lordship. And next lordship, train and graduate teacher, junior
undergraduate,
Lordship, kindly see, Lordship, payment two, 5200, 20200, and grade pay Lordship would find 2300. If I Lordship come to page 132 Lordship of the affidavit of affidavit and reply filed by the present petitioner Lordship, that figure was changed Lordship, modified, revised Lordship, with effect from 19 to 2021 Lordship.
Page number,
11.
page number.
Page number 132 Lordship.
Put back to 130.
132.
Yes.
Lordship finally see that serial number 9. That Lordship grade pay 1300 has been revised to 2700. Lordship got it? The grade pay of 2300 has been revised to 2700. Lordship. On the other hand, Lordship, in serial number 13, Lordship would find grade pay 2800 has been revised to 3300 Lordship. Again, applying to 153 of that ROP rule Lordship, it is clear that the revised pay, the petitioner is getting the grade pay of 2700 was meant for graduate teacher in a Lordship, 10 and graduate teacher in a junior level Lordship. He is not the headmaster nor the graduate teacher science Lordship.
I'm the science teacher.
Lordship, may I able to clarify Lordship? In school, there was another science teacher, graduate teacher, science is also working Liladhar Paithai. In my affidavit, I have stated. Though the petitioner is a graduate in science, but he is not taking the post of graduate teacher science Lordship. He may have he has also science graduate, but he is not that holding that post Lordship. Graduate teacher science, as per ROP Lordship, graduate teacher science, which I have just pointed out Lordship. Now Lordship, am I Lordship? Here Lordship.
Yes.
Now Lordship, again Lordship, page 99 Lordship. So thereafter, page 99 Lordship, paragraph 2. Thereafter, the petitioner was drawing regular pay and allowances of grade pay rupees 2700 June 31 key 2016 as per Assam Service Division of Payroll 2010 and payment number social grade pay 8700 with effect from so as per ROP 2017 Lordship. That 2700 grade pay was revised to 8700 in 2017. It is also stated that there are graduate teacher posts and intermediate posts in ME, MB, MEM school. In both category of teachers are entitled to enjoy payment too. However, grade pay 2700 was paid to the teacher appointed against the post of intermediate teachers who had graduate degree with diploma in elementary education, and grade pay rupees 3300 was paid to teacher appointed against post of graduate teacher till 31/3/2016 as per ROP rule 2010 Lordship. Lordship, this is the actual position of the fact. Thereafter, some service division of payroll 2017 came into force with effect from 1/4/16, whereby graduate teachers working against graduate posts of higher and higher secondary school, as well as all teachers, ME, MB, MD school, irrespective of graduate schools or intermediate schools, have been allowed to draw grade pay of rupees 8700 under payment to Lordship, provided ME, MB, MEM school teachers should have graduate degree with diploma in elementary education. In regard to headmaster and science teacher of ME, MB, ME Madrasa school, who is appointed against the post of science teacher are graduate posts and rest are intermediate schools.
Prior to the ROP 2017 came into force, only the headmaster and the teachers appointed against science graduate schools were drawing graduate scale of pay in payment with grade pay 3300. While petitioner was drawing payment to 5200 to 20,200 with grade pay to 700 only. Assam Service Division of Payroll 17 came into force with effect from 1/4/2016, wherein besides teachers working against graduate schools, all the teachers working against intermediate schools having graduate degree in any disciplinary diploma and elementary school has been allowed to draw pay and allowances as get pay of 8700. As such, petitioner was entitled to draw 8700 with effect from 1/4/16. Further, the deponent humbly submit the view of the financial advisor. That's the view of the financial advisor as projected in earlier also. As per ROP Rule 10, fitment table 9, pre-revised scale was so and so is revised to payment 2 of CP 2700. That get pay 2300 is revised to 2500 by another notification with effect from 1/1/11. The same is not graduate scale. Even the get pay of rupees 2700 allowed after passing change is not a graduate scale. Therefore, petitioner, that is Audit Das, has been drawing graduate scale of pay of 2800 with effect from 1/4/16.
Okay. Lordship,
The sum and substance of the extent of the department is that the petitioner before that Lordship, the sum and substance of the department is that so the petitioner was allowed to draw get pay of rupees 8700 Lordship after coming into force ROP 17 Lordship. Prior to that, he was drawing initially get pay 2300, which was revised to 2500 and then 2700. That 2700 get pay which petitioner was drawing was allowed to the teacher having graduate degree and training, but his post was not a graduate teacher post. As graduate teacher post, science graduate teacher post, as I have pointed out in the ROP fitment table 9, it is a separate post, not the which was not held by the petitioner. So his graduate teacher after amalgamation, his graduate teacher's claim would be entitled only from that 2016 Lordship, not prior to that. Therefore, on 2021, he was lacking 10 years experience to include him in the post of or principal post of headmaster.
okay.
That is Lordship.
Okay, we'll pass the order.
Marks. Marks.
Maybe. Do not. You only? Well, this is regarding an appointment of the helper of the Anganwadi center. It's the board. So there is a notice Miller, advertisement notice, kindly see Miller, that is annexure 1 page 15. Starting Miller. And particularly is there Miller also Miller. In Assamese portion Miller, you should kindly see Miller. The name of the center Miller, page 19 in Assamese Miller. Badangnunga, Tiniali, General, so post is helper, Hoika. And Miller, next page Miller, page 20. Conditions, what are the terms and conditions of the appointment? Number 1, Miller, candidate should be Miller, lady. Number 1. And
Number 2, my lord, is okay, my lord, is the problem. And 3, my lord, Anganwadi Kormi Podor Babe higher secondary pass. And helper, my lord, helper, third line, my lord, Hoika Podor Babe Anganwadi Babe, আবেদনকারী প্রার্থী নিম্নতম শিক্ষাগত অর্হতা হাই স্কুল হাই মাদ্রাসা পরীক্ষার উত্তীর্ণ হব লাগিব যদি হাই স্কুল শিক্ষার্থী পরীক্ষাত উত্তীর্ণ প্রার্থী না থাকে তেনেহলে নবম শ্রেণী উত্তীর্ণ প্রার্থী আবেদন কৰিব পাৰিব। That is my lord. I have passed 9, not I have metric. So for the helper post, my lord, I am qualified to apply. 4, my lord, অঙ্গনবাদী কর্মী সহায়িকা পদৰ প্ৰার্থী স্থানীয় বাসিন্দা প্রমাণপত্র গ্রাম্য এলাকার ভাবে সচিব গাঁও পঞ্চায়েত সেক্রেটারি সভাপতি এটসেট্রা আদিৰ পৰা গাঁওবোৰৰ পৰা গাঁও পঞ্চায়তৰ পৰা প্ৰদান কৰিব লাগিব তেনেকুৱা হ'ব লাগিব। আনহাতে নগৰ অঞ্চলৰ so not গাঁও পঞ্চায়ত or not yes গাঁও পঞ্চায়ত or গাঁওবুঢ়া they should issue certificate to that candidate and that is given to me. Number 5, my lord, অঙ্গনবাদী কর্মী সহায়িকা পদৰ প্ৰার্থী আধাৰ কাৰ্ডৰ স্বপ্ৰত্যয়িত ফটোকপি গাঁঠি দিব লাগিব। Aadhaar card should be there, my lord. Yes. And last, my lord, page 21, which is not so clear, বা নিম্নলিখিত কাৰণৰ বাবে প্ৰার্থী আবেদন নাকচ কৰা হ'ব। আবেদনকারী প্ৰার্থীগৰাকী মানসিক বিকারগ্রস্ত হলে। নাম্বার, my lord, 4, স্কুল কলেজৰ নিয়মীয়া ছাত্ৰী হলে। So my submission will also is this. As per advertisement, my lord, I am qualified, I have applied. But I was not selected as because, my lord, herein the respondent number, the private respondent. He was, my lord, outside person, my lord, here now she has been appointed, selected and appointed. And petitioner, my lord, I have given, my lord, GP certificate that is annexed to page 22, my lord. I have passed class 9, my lord, that is, my lord, I have given annexed 3, page 24. And my lord, also Aadhaar card, I have given plus annexed 4, page 26. All that annexed as per advertisement. Interview has, I was not success, and list of candidates was given, my lord, annexed 5, page 27, list of candidates. Now, my submission is for number 6. The center is, my lord, at, your lordship has seen, it is, my lord, Badangdonga village. And the person, my lord, who is selected and appointed, he is from, my lord, Shimlabari. Shimlabari, another, my lord, the center area.
Mr. Sotia,
My lord.
on the other day, Mr. Zeke Gustami entered appearance. He submitted before this court that the survey register is necessary.
Yes, yes.
Whether that register
Yes,
is
yes,
available?
I have received it.
Okay.
And my lord, yes. And the resolution 6, 7, my lord, has not annexed here, my lord, the Aadhaar card or voter card or government certificate, nothing. I have not found.
It is clarified, but still within that area.
And yes, I am coming to that, my lord.
Okay.
So, my lord, after selection, my lord, public file a petition that she should not be appointed or allowed to work there, my lord, and that is there, my lord, yes. And another, my lord, she is my submission was on the last occasion, my lord, she is a, my lord, respondent number 7. He is a regular student, my lord, of a higher secondary school. So the principal has issued a letter, my lord, that is annexed 7, my lord, I may kindly see. Annexed 7, my lord, yes.
Annexer?
Annexed 7, page 32. This is type my lord, photocopy is below, my lord. The principal issued a letter, my lord, to the CDPO, stating that, my lord, subject regarding clarification about the regular student of Ruksana Khatun, he is a private respondent, daughter of Swan Samila of Village Simlabari. post office Shimlabari. Sir, with reference to the subjects cited above, I have the honor to inform you that Rukhsana Khatun, daughter of Shahadut Al Islam, Shahadut Islam, village Shimlabari, post office Shimlabari, district Gwalpara, Assam, has been a student of Gaunagar Senior Secondary School till 29 October 2024. And as per our school record. But as per the written application submitted by her, she desires to be discontinue her further study in our institution due to economical crisis of our parents. Moreover, she remained absent in the process of examination from form fill up for the upcoming HS final examination 2025. There is a letter, but it is not a certificate. It is a letter issued by the CDPO, sorry, yes.
Last sentence.
To the CDPO.
Last sentence.
It should be.
Okay, last sentence. And she is not present in a school now.
Yes.
So
Not
why
received.
avoiding the pushkar?
Yes, now you have added, so it is clear. So, Millard, this is the not certificate. This is the letter issued by the Millard principal to the CDPO.
So at the relevant time, she was not a student
Yes.
as per this letter.
October 24, advertisement made in the 11, November. Thereafter, advertisement.
All Millard,
During the period of advertisement, she was not a regular student. He left out the school. That is the same stuff. So the first criteria, he said pilot to be a no candidate to be a regular student. That is gone by. And another
that
is
point, Gordon.
area. Area is pilot. I have submitted
No.
here pilot.
Let me
Moreover, she is underqualified. She is class 9.
No, let me complete. Okay, please, all of us have. Class 9 also Millard can apply. When I can apply, I may be selected. But in this case, I am not selected for other reason. As because my submission is a private respondent Millard is an outsider. He is from village Shimlabari and I reside in village Bhadangonga. Same within the same state area Millard. Yes. And Millard, the respondent Millard, CDPO filed an affidavit Millard. I have filed the reply to them Millard. CDPO has mentioned that I am not qualified, unqualified. But as per the advertisement, 9 parks or so Millard can apply. When I can apply Millard, may be selected. This number 6 Millard was selected and appointed. There is a statement of the Millard CDPO. And also Millard paragraph 8 mentioned that this name of the respondent number 6 Millard enlisted in the supervisor, enlisted in the supervisor's list. There is a list Millard surveyed by them Millard and that is Millard within the area. That is their submission. And my submission on that point I have stated and I submitted the reply Millard. There is no any other document of the respondent number 6 that she is a resident of village Millard of the Anganwadi area. No voter card, no Aadhaar card, no government certificate. This should be there as per the advertisement. Nothing. And as because Millard, respondent number 6 and 7, they are Millard, my sister-in-law Millard, both. So Millard, 7 is working under them Millard, as the Millard Anganwadi worker. So Millard, she is the Millard making the all surveyor, and he has Millard intentionally put her name within the center area. And I'm coming to that also, Millard, yes. I have filed an application, Millard, kindly see, that is the yellow, kindly see. On application, Millard, that is filed on 19/11/25.
Page number?
Page number, Millard, 43. Start. That is original evidence, Millard. As a lawsuit got it.
Yes.
Here, Millard, I have mentioned here that the paragraph 2, respondent number 6, particulars mentioned Millard 10 to 23. That is Millard page, an action Millard, yes. Page 47, 11%, my lord. Integrated child development scheme, my lord, particulars of family district corporations, my lord, ICDS project, Joleshwar area, my lord, that is Shimlabari. The Lashmi kindly this not area. Onganbadi center, Swanson, my lord, there is the Kulabari Sorkar Para, Swanson. Worker Rohila Khatun and Onganbadi helper, Sohida. And next page, my lord, that is page 49. It is the survey report, my lord, kindly see page 49, annex 10 continuation. Here is the particulars of the family, my lord, particular is given, my lord. Serial number 5, Ruksana Khatun, he is the restaurant number 6. 1, my lord, 21, it is the date of birth, my lord, 21/1/05, date of birth. It was surveyed, my lord, by the who surveyed, my lord? That is, my lord, chairperson, Rohila Khatun, chairperson, Kolabari, Sorkarpara, AW Anganwadi Worker Center, and Joleshwar ICDS project, Bohanagar. That means, my lord, it is the center of, my lord, another center, not with our that center in which the case is presently going. That is Bandanganga, not. So she is an outsider, my lord. And also, my lord, page 51, annex 11. Ruktana Khatun. He is the respondent number 6. He is an appointed, selected and appointed, my lord. There is a similar, my lord, that is survey particulars of the family, my lord. There is his family, her family, and he is serial member of the Ruktana Khatun, serial member 5. And it was also, my lord, Rohila Khatun, chairperson, Kolabari, Shokarpara, AWC. So, my lord, it is another center area, not within the Badangalanga area, my lord. And, my lord, another kindly see, my lord, page 53. There is the survey report, my lord, 2724. As you show. It is, my lord, Badangalanga, Tiniali, and Anganwadi Center. It was surveyed on 2724. And, my lord, her name is found here, my lord. Yes. Serial number 4, my lord, Ruksana Khatun. And it is on the issue by Shohida Begum, Secretary, AWC, Managing Committee, Bandhangananga Francis Anganwadi Center. Earlier, my lord, this is another center, and within the, my lord, some with a short period, now her name has been migrated to, my lord, the present center. Where, my lord, she has been, I am deciding, and she was earlier another place. So my submission, my lord, she is on that point. Only when she is an outsider totally, my lord, and her name has been, my lord, in illegal manner brought her name to this center, my lord. With, my lord,
Yes.
5, yes, my lord, 6 and 7, my lord, they are the one is, my lord, the brother's wife, 7,
Okay.
and 6, my lord, is the candidate. So the selection, my lord, totally, my lord, on. So that may kindly be done. Oh, ठीक है, good. That's okay. Oh,
Yes, my lord. Kindly see page 27.
yeah.
27, this is about the list of candidates. Those who is applied for the school from helpers. Page 27. How many candidates? 6 candidates were there. Out of 6 candidates, 1, 2, 3, 4 candidates pass SSLC examination. They are qualified. It should have serial number 1, she is under qualified. She is class 9. Suppose her certificate has been, my lord, I have seen it, my lord. He left the school in 2007 and began issued in 2004, just before the advertisement. However, he passed class 9 and others, four candidates passed 10. matriculation. So as per advertisement, qualification is 10 or higher secondary. If there is no candidate, then only class 9 candidate can be considered. So she is totally out from the selection.
Okay.
Further argument is not necessary, my lord. She is not qualified. If she is not qualified, how she can challenge the other my lord selection? That is the first point. So far, regular, another point is my lord, regular student is concerned. That is my lord, as per my lord, certificate issued by the principal. Yes. One more question. Certificate. Certificate रहेगा, annex किसी होगा. Annexer 7. And also balance is annexer 7. It's clear, man. It says to the clerk, higher level of project officer. Perhaps matter refers to his CDPO letter. Perhaps CDPO by letter dated so 29 November 2000 asked the ballot principal authority whether she is regular student or not. Against this letter, my lord, this reply is submitted by the principal. Principal has not issued its own. The reference is there, subject. Reference, reference CDPO. This has already been pointed out, my lord. He has been a student of High School till 29th of October 2024. And advertisement made my lord 1st of November 2024. So before advertisement, she was a student of class 11. Studying class 12, but she could not complete due to her financial crisis. So as a matter of fact, my lord, she was not a regular student. It must be a regular student. And as she is not presently studying in our school, so this letter is issued on 4/12/2024 because she has left the school before advertisement. So she is qualified. And regarding outsider ballot, she is not outsider. I have started before what she did a evaluation. Her name is there. And father name is there, so and so it is there within that area. So there is nothing. The first of all, petitioner is underqualified, and underqualified candidate cannot challenge the qualified selected candidate. He has no external right. Not only that, if had it been only the respondent number 7 and her petitioner is the candidate, that would be different thing. Now there are the 4 other candidates. Competition is there. Among the 4 qualified candidates, respondent number 6 is selected. This is a question of as per the condition of the advertisement. If there is no qualified candidate, that means class 10 or 11 is not there, then class 9 is to be considered. These points says, my lord, she is underqualified, class 9. Her itself, admitted that she is underqualified. And our selection committee also is mark it in a white, make it candidates particulars, she is underqualified, box, page 27. Remark column, underqualified. And other serial number 4, under open, underqualified. And serial number 5, open school. And she is the one of best candidates. She studying in the she was studying in the class 11. So there is no question of passing any class 10. She has already. And she
So there is a decision of Supreme Court on this point that underqualified candidate cannot challenge the selection of other candidates.
Yes.
But my submission is not
That-
underqualified. As per Millet
decision is
advertisement,
available with you.
only one sentence, Millet. নবম শ্রেণী উত্তীর্ণ প্রার্থী স্কুলের প্রমাণপত্র স্কুলের সমাধান মিলার ইয়েস যদি হাই স্কুল পরীক্ষার্থী
Mr. Rosit, please sit down, let him complete.
না অনলি ফর রিপ্লাই ও মাই লর্ড ইয়েস
And another document also I have received regarding the document of the responsibility, all its qualification certificate and other. And there is nothing, but the petitioner has no case for not work.
Actually, nothing other reply.
Okay. Any other point? No.
No, man. But I have submitted all these things, Malad, he is not at all, Malad, right?
And
The post of Malad.
Yes, Mr. Rosid.
well, only two reply, Milad, regarding qualification, Milad. Here the advertisement, it has mentioned, Milad, page 20, in particular, Milad. যদি হাই স্কুল শিক্ষান্ত পরীক্ষায় উত্তীৰ্ণ প্রার্থী নাথাকে তেনেহলে নবম শ্ৰেণী উত্তীৰ্ণ প্রার্থীও আবেদন কৰিব পাৰিব। That means 9 pass students or a candidate also qualified to apply. And herein found, Milad, the person who is Milad has now selected, he is an outsider. Kindly see, Milad, the letter of the Milad headmaster. He has written a letter, Milad, kindly see to whom. Page, Milad, that is annexure 7. Yes. Page, Milad, 32.
Page
32. It is the letter written by the headmaster principal, Milad, to the CDPO. And for whom, regarding, Milad, subject, Milad, on the same letter, Milad.
No, you have already read this.
No, only, Milad, as because my learned say, who is the local? Our total address is Milad at Shimlabari, not at Milad, now present place, Milad. Can you see that is, I am mentioning, regarding the clarification about the regular student of Ruksana Khatun, daughter of Shahad Ali Islam of village Shimlabari, post office Shimlabari. And
No,
Shimlabari
you see the
is
last line.
another place, Milad, not the same area, Milad.
She is not presently studying in our school now.
Yes, but the address is same, Milad. Address is not sense. Address is the same place mentioned, earlier address.
Okay,
Address in 24 is the same, and in 26.
we will pass the order. Yes, next item.
Coming item 4. Passage letter.
PJ কোন আছিল না? Mr. Sharma, the other side is absent.
Well, in fact, we have
let the court master contact them after some time.
They have concluded their part, my lord. I have to give my reply.
Oh, you were supposed to give your reply.
My lord.
Yes, but in their absence, if we
My lord,
hear
let
you,
them be
then
there. We'll try to contact. My lord, I'm sorry, my lord. When the matter was called, I was in court number 1, my lord. That's why.
no problem, no problem. Next item.
Number 9.
May please the lordship. The matter was earlier heard and this honorable court has passed order dated 27/8/2025. 27/8/2025, directing to produce the recommendation of district level committee. No, well, the original order is 27/8/2025.
I'm saying, same thing, 411, the argument concluded only, I think.
No. Argument was concluded earlier. Lordship may kindly have a look at the order dated 27/8/2025. That was the original order. After hearing the parties, the Lordship has directed to produce the recommendation of the district level. If any other communication is produced, my lord, lordship has not called for that.
Produce the resolution of the state level.
That is available here.
Yes, sir.
Okay.
I flag mark my, there are, in one green flag mark is here with the my notes.
Okay.
Then, one,
Orange,
one, blue.
green color.
Blue flag mark is there, there, the name of the respondent is here. Blue one is below.
Pink and orange.
Okay, okay.
It's name stone, name stone of the practice, but then orange. Orange is the recommendation. Name of the petitioner has not been recommended, madam. Only the name of the petitioner has been recommended and thereafter.
Okay.
My lord, my humble submission is that our
Today we are not supposed to reopen the argument.
my lord, no, we are not arguing, my lord.
Yes.
Only
then-
point is that after hearing the parties, your lordship has passed order on 27/8/2025, calling for the recommendation of the district level, not this my lord, the SLC, my lord. Or SLC is not required because SLC has already, the state level authority already has passed impugned order. That is under challenge, my lord. So my query was that my recommendation lordship has seen, and their recommendation, what was their recommendation by the district level, that was to be seen, my lord. On that point, my lord, lordship has passed order 27/8/2025. My lord, I am reading the order. I've heard so and so, so and so.
Mr. Sigdar, today there was direction only to produce the relevant file containing the resolution of the SLC.
My lord,
Mr. Das has produced it.
my lord,
We will pass the order.
my lord, my lord, what will be the fate? What will be the fate of the earlier order, my
You
lord?
have already argued.
My lord, lordship has called for 27/8/2025 by order date 27/8/2025. My lord, what was their recommendation by the district level? That was my point, my lord. My recommendation is different, okay, but what was their recommendation? By that was, my lord, the lordship has considered directing the to send the 27/8/2025, my lord. The order is, my lord, written as like I am reading, my lord, after hearing the both the parties.
Mr. Das, that district level selection.
One record has already been produced earlier. That is, I think, tagged with the files. Thereafter, my lord has directed that.
SLC recommendation.
Yes, my lord.
First. Okay. Okay.
My lord, there is specifically note, my lord. After hearing both the parties, it is provided that MS Fukon and Mr. Das shall produce the recommendation of the district level committee as
The
mentioned in the
the
order.
file was produced before the court.
My lord,
File was produced before the court.
my lord. So, okay, if it is there, my lord,
Mr. Sigdar, learned counsel for the petitioner. And Mr. S. Das, learned standing counsel for the respondent in higher education department. Mr. Abedin for respondent number 7. And Madam Borman, you are for respondent number 3 and 4. 3 and 4. And Mr. A.M. Ahmed, you are? Okay, the same. Are present and person to order dated 18/12/2025, Mr. S. Das, learned standing counsel for the higher education department, has produced the SLC recommendation before this court. Then argument already completed. Judgment reserved.
Pending item 4. Contact করে আসো ওখানে contact করে।
A friend has come. My lord, just to refresh your lordship's memory, my lord, in this writ petition, the challenge has been made to the order of penalty in a, my lord, penalty of removal from service after a disciplinary proceeding. Now, the point which I urged, my lord, in my argument, my lord, was that, my lord, there are 4 or 5 grounds that, my lord, the inquiry officer was appointed before the issuance of charge sheet. Therefore, my lord, that cannot stand. The second point was that, my lord, the charge sheet was neither placed before the disciplinary authority, which is the, my lord, executive council, neither it was ever approved by the council. Therefore, it is known as in the eye of law. Then, my lord, the inquiry proceeding also, inquiry report, if your lordship notes down, my lord, because I want to be brief, my lord. So first position is that, my lord, the first ground of challenge is that the inquiry officer was appointed prior to issuance of charge sheet. Therefore, the charge sheet cannot stand in the eye of law. Secondly, the disciplinary authority is the executive council. The charge sheet was never placed before the executive council, nor it was ever approved by the executive council. Therefore, the charge sheet is again known as in the eye of law. Then, my lord, the inquiry report gave perverse findings. The findings are perverse, and therefore your lordship is, my lord, that is liable to be interfered by this honorable court. Then, my lord, there is a finding that is the stand of the university that whatever has happened, my lord, it was regarding running of certain courses in this new idol. That was an error of judgment. They have themselves, my lord, stated before the, my lord, the other authorities, universities stand, that it was an error of judgment. If it was an error of judgment, that, my lord, cannot attract as a, my lord, penal consequences as a misconduct. I'll show, my lord, where they have stated that it is an error of judgment. The university has stated. Then, my lord, the charge memo lacks specifics. And, my lord, the petitioner has been picked up for differential treatment, and others who are also responsible, my lord, as per the report of the Psychia Commission, which was constituted to inquire into the, my lord, the allegation that unauthorized courses are run in GU idols. Only, my lord, the petitioner has been picked up. So that, my lord, others are scot-free. And they have, my lord, given statement against me before the commission. Now, my lord, although, my lord, I have placed my submissions and the learned, my learned friend, Mr. Saikia, has argued for 2.5 hours, my lord, the other day. The charge sheet was, my lord, not read before your lordship. May I read that, my lord? The charge, what are the charges against him? The charge sheet your lordship will find this one. Page 55. This is the memorandum of charge. Your lordship may kindly read the articles of charges at page 56. That the said Dr. Article 1, that the said Dr. Kandarpadas, who is the petitioner, while functioning as director, GU Idol, has started and ran 21 unapproved courses, and which
continued during the period 2010 to 17 as observed in CAG report, which constitutes violation of Rule 4 of Gauhati University Teachers Conduct Rules 1984. My lord, I'll show that, my lord, these courses started much prior to the petitioner becoming a director and also continued after he demitted his charge. Then Article 2, then Dr. Kandrapo Das, while functioning as director's EU Idol during 2010-17, continued the above unapproved courses in spite of his having knowledge of the mandatory requirement of approval of the course by the DEC, UGC. This constitutes violation of Rule 4 of the Gauhati University Teachers Conduct Rule. Then Article 3, though the approval from Distance Education Council UGC was necessary to run the courses in GU Idol, appropriate steps were not taken by Dr. Das when he was the then director of GU Idol. Then Article 4, as many as 73,912 students were enrolled and passed out on completion of alleged unapproved courses during the period from 2010-11 to 16-17, making them ineligible for central government services, thereby threatening their future employability. In spite of being well aware of this deficiency, Dr. Das, who was the director during this period, allowed the courses to run. This constitutes violation of Rule 4. Then Article 5, DEC, UGC were unaware of running of such alleged 21 unapproved courses of GU Idol during the long period of 7 years, that is 2010 to 17. Dr. Das, as head of the Idol, during this period, failed to intimate DEC, UGC appropriately, which constitutes violation. Then Article 6, though well laid down procedures were prescribed or in existence for getting approval of courses offered by GU Idol from DEC, UGC, the same was not followed properly by Dr. Kandrapo Das, and his decision of continuing the unapproved courses is not justified. This constitutes violation of Rule 4. Article 7, irregularities committed by GU Idol authority under Dr. Das by running the unapproved courses resulted in avoidable expenditure. This constitutes violation of Rule 4. So, my lord, these are the, my lord, 7 charges. Now, your lordship will find, my lord, this evolves around the fact that, my lord, there were some courses which were not approved by the UGC, and that was run, and the petitioner is, and petitioner, only the petitioner is responsible for that. That is what is sought to be, my lord, established by the charge sheet. In fact, my lord, allegation is that he started these courses. Now, my lord, the procedure which has to be followed in a disciplinary proceeding, that has been, my lord, clearly stated in Assam Service Discipline and Appeal Rules. Although your lordship has read it time and again, may I implore, my lord, once again, I place Rule 9. Because the procedure, I'll show, my lord, the procedure has not been followed. Which will, my lord, establish my first 2 allegations that an inquiry officer was appointed prior to, my lord, issuance of charge sheet, and that the charge sheet was not approved by the disciplinary authority. For that, my lord, may I read your lordship?
After 5 minutes.
My lord.
Yes.
My lord, may I refer to Rule 9? Rule 9 of the Assam Service Discipline and Appeal Rules. My lord, I am assuring your lordship, my lord, I will not be re-arguing the matter. I will only, my lord, point out those which are necessary to, my lord, rebut what my learned friend Mr. Saikia has submitted before your lordship. Your lordship will come to Rule 9, procedure for imposing penalties. The proceeding has been initiated under this rule, Assam Service Discipline and Appeal Rules. Without prejudice to the provisions of the Public Servant Inquiry Act, no order imposing on the government servant any of the penalties specified in Rule 7 shall be passed, except after an inquiry held as far as may be in the manner hereinafter provided. 2 is important. The disciplinary authority shall frame definite charges on the basis of the allegations on which the inquiry is proposed to be held. Such charges, together with statement of the allegations on which they are based, shall be communicated in writing and all Now, my lord, it is the disciplinary authority which has to frame the charges. Now, my lord, as I have submitted, disciplinary authority, my lord, the charge sheet was never placed before the disciplinary authority. It was never approved by the disciplinary authority. Therefore, my lord, Rule 9(2) has not been followed. Then your lordship may come to sub-rule 5. Rule 9(2) requires the charges to be framed by the disciplinary authority. In the case of the petitioner, disciplinary authority is the executive council of the university. There is nothing to show on my own record, documents on record, that it was ever placed even before the executive council or approved by the executive council. Then your lordship will kindly come to sub-rule 4. On receipt of the written statement of defense, or if no such statement is received within the time specified, the disciplinary authority may itself inquire into such of the charges as are not admitted, or if considers it necessary so to do, appoint for the purpose of a board of inquiry or an inquiry officer. So, my lord, the consideration by the disciplinary authority to appoint an inquiry officer comes only after the written statement is filed. Because, my lord, I may admit all the charges, then, my lord, there is no question of inquiry, I can be penalized. Or maybe, my lord, they may be satisfied with my written statement. In that case also, my lord, no inquiry will be necessary. But here is a case where before issuance of the charge sheet, unapproved charge sheet, they had already appointed a disciplinary authority. So I'll not refer the other parts, these are relevant. My learned friend, Mr. Saikia, has, my lord, taken so many points, 4 or 5 points, my lord. The first point he had taken is that alternative remedy of appeal was there, but writ petition was filed without preferring an appeal. That was one of the grounds. Because Assam Service Discipline and Appeal rules provide for appeal, but appeal was not filed. The explanation of the petitioner is that, my lord, petitioner was earlier Jagdish Mukhi, and, my lord, he had placed the petitioner under suspension and initiated a proceeding against the petitioner. So at the point of time, my lord, when the order of removal was, my lord, the order of penalty was passed by the Gauhati University, he was the chancellor. Therefore, my lord, and my lord, the charges also, my lord, in KK Hendy University were similar to that, what is there in the present case. And therefore, my lord, an appeal would be, my lord, an appeal from seizure to seizure. And, my lord, it is not efficacious. When, my lord, the remedy is not efficacious, my lord, alternative remedy is not, my lord, course to be followed, my lord, compulsorily. Because, my lord, I have already shown, my lord, at page 77, your lordship will find the Honorable Chancellor has already formed an opinion against me. Therefore, the appeal will be a futile exercise of time. Alternative remedy is not an absolute bar, and when it is not efficacious, your lordship may entertain. The second point, your lordship, my lord, I will not read that. Your lordship may read that at, my lord, page 77. And, my lord, I have already made these averments in paragraph 46 and 49 of the writ petition at page 29 and 30. I will not read that, my lord. I have already made an averment. Why, my lord, an appeal has not been preferred? That your lordship finds at page 29 and 30, paragraphs 46 and 49. I have explained that why I have not preferred an appeal. That will be not an efficacious remedy. Now, my lord, the second point, my learned friend, Mr. Saikia, argued was that no show cause notice was required to be given before imposing an order and penalty. Well, this I have not argued, my lord. Therefore, I am not pressing that because I have not argued that. Because he said that before imposition of penalty, a second show cause notice was necessary. We said, and that it was not necessary. What is he said, my lord? We have never argued this point. Therefore, your lordship may skip this. Now, the other point my learned friend argued is that the UGC and Distance Education Council rejected the proposal to continue with the unapproved courses, but in spite of that, the petitioner continued with the course. Now, my lord, my reply to that is that there is no document on record to show that at any point of time UGC has rejected or directed to discontinue with the unapproved courses. What happened, my lord? All the courses were placed before the UGC, and my lord, UGC has allowed some courses to be run, and there was no rejection, and therefore, my lord, the procedure followed. That started prior to the petitioner joining as director and also subsequent to petitioner demitting that office. So, my lord, it is not true to say that the UGC or Distance Education Council has ever rejected the proposal to continue with the unapproved courses. But then, my lord, there was no rejection or refusal. So, my lord, the approvals come, my lord, part by part. And my lord, this PG correspondence school, as was earlier known, this IDOL, my lord, that came into existence in 1998. Your lordship may kindly note down the dates during which I was the director. I was director from 19/8/2006 to 31/1/2016. 19th of August 2006 up to 31st of January 2016. 31/1/2016. This is the period when I served as director. Now, the postgraduate correspondence school in the Gauhati University came into existence in 1998, which was subsequently named as GU IDOL. It was run without a director only in, my lord, 2005, that is on 29/10/2005, the Executive Council of the Gauhati University decided that we should create a full-time post of director. That your lordship will find at page 701. In the affidavit, my lord, affidavit in reply, my lord, page 701, specifically at 703. So that was on, my lord, 29/10/2005. At that point of time, my lord, before the petitioner joined on 19/8/2006, my lord, there were two directors. One is, my lord, Professor B.P. Setia, and the other is Professor Srinath Borua. Then, my lord,
You have referred to page number 700
701, my lord, that is the additional affidavit.
7.
Affidavit in reply, my lord. Filed by the petitioner.
What? Yes.
This is, my lord, order dated dated 29/10/2005. The relevant part, my lord. Your lordship may come to 1703.
Yes.
Report of the committee constituted by the Executive Council, Gauhati University, to examine the feasibility of creating a post of full-time director of the postgraduate correspondence school, Gauhati University. Then, my lord, that was decided. And, my lord, this also indicates second paragraph, your lordship will find, my lord, the courses that those were already being run. Postgraduate Correspondence School of Gauhati University was established through a decision of the Executive Council dated, my lord, that is not very clear, June 1998. Meanwhile, the Vice Chancellor had constituted a postgraduate correspondence school. Board of University notified by the Registrar GU by notification dated 3/4/1998. Subsequently, the Academic Council of the University in its meeting held on 23/9/98 approved the scheme of postgraduate correspondence course in 6 subjects, namely Assamese, English, Economics, Mathematics, Political Science, and History. In addition to the subject mentioned here, the Academic Council also approved subsequently the scheme of PG correspondence course in 2 other subjects, namely Commerce and Philosophy, and 4 diploma courses. These, my lord, courses are named. So, my lord, before the petitioner joined as director, these courses were already being run. And, my lord, there are 2 directors, my lord, who preceded me. And, my lord, the report of the, my lord, Justice Saikia Commission, I'll refer to that, my lord, the ultimately what is recommended. That says that, my lord, the action should be taken against the persons involved. I am not the person involved. I am not the, if I am at all, my lord, a person involved. Firstly, my lord, I am the director. I am neither a member of the Academic Council nor a member of the Executive Council. Therefore, my lord, I cannot take any decisions. Decisions are taken by the Executive Academic Council and approved by the Executive Council. And these courses were run prior to, my lord, the petitioner joining as director. And subsequently also, after the petitioner ceased to be a director, then also, my lord, these are continuing. And the, my lord, Justice Commission, Saikia Commission report says you take action against the persons who are responsible. Responsibility comes on the members of the Academic Council, Executive Council, and which is headed by the Vice Chancellor and particularly the Registrar. Now, my lord, since your lordship has taken up this, my lord, additional affidavit, may I implore your lordship to come to page 707, my lord. That is the minutes of the advisory board meeting held on 21/7/2016. The Vice Chancellor was there. The then director was there. My lord, 2016, my lord. The registrar was there. After, my lord, the petitioner, my lord, demitted his office, there was another director, there was the registrar, there is the Vice Chancellor. My lord, I'll skip the first part. The meeting resolved as under. The UGC DEB be required to elaborate on page 3 of the letter of UGC under discussion, which states that 3 new courses not allowed. The institute should seek clarification on the 3 new programs that are not accepted by the UGC DEB, New Delhi. As the process of admission to different programs is getting delayed due to non-receipt of approval communication from the UGC DEB, the board resolved that admission to the offered courses should start immediately for the greater interest of the students. In case of any action of the UGC DEB on matters of programs offered by GU Idol, which might affect the future of the students seeking admission to GU Idol or those already enrolled, as also the people of the state at large, the board authorized the university to take appropriate measures of appeal to UGC DEB petitioning to MHRD, Government of India, through appropriate authority as well, to seek legal remedies if necessary. These resolutions are adopted, keeping in view the future of the thousands of aspiring students and learners and the people of the state at large. So, my lord, even after the, my lord, petitioner ceased to be a director, they were running courses, introducing courses, which are not approved. And you want to blame the petitioner alone. My lord, this letter and, my lord, other documents will also show, my lord, the advisory committee, the executive council, the academic council were all aware, my lord, all through that prior to petitioner joining as director, they were running unapproved courses. after the petitioner became, my lord, he remitted office, my lord, after he completed his tenure, then also, my lord, they started new courses. So, my lord, they cannot, my lord, feign ignorance of the fact that they all knew. And, my lord, the petitioner has been singled out. Saikia Commission, my lord, held that all are responsible. The petitioner was picked up to make a scapegoat, to save the, my lord, skin of the others. My lord, if your lordship comes to the Saikia Commission report, my learned friend the other day, my lord, made several, read, my lord, several statements. I will not read those statements, my lord. The statements made by the registrar, the other persons, my lord. The report your lordship will find at page, report to person, page 258. I'll, my lord, read only some related.
Yes.
Has your lordship got in mind? It starts at 258. Dr. Justice after Hussain Saikia Commission, one-man inquiry commission. Now, your lordship may kindly come to the, my lord, the reference made that your lordship finds at, my lord, page 264. Gauhati University, while resolution number such and such adopted by its executive council on 4/12/2019 constituted one-man inquiry commission to be headed by Dr. Justice Aftab Hussain Saikia, former Chief Justice of the High Court of Sikkim, etc., to inquire into the anomalies indicated in the report of the Comptroller and Auditor General of India pertaining to Gauhati University Institute of Distance and Open Learning, hereinafter called the GU IDOL. Accordingly, the registrar's U by communication dated so-and-so requested Dr. Aftab to conduct the inquiry seeking consent. This is the letter, my lord, written by the then registrar. Then your lordship may kindly come to page 65, last two sentences. Terms of reference. To inquire into alleged irregularities as regard continuation of 21 number of unapproved courses in GU IDOL during 2010 to 17, as reflected in CAG report and recommendation of appropriate measures thereof as deemed fit. Now, my lord, various persons, various officials, officers of the university made their statements. I'll not go into that. My lord, your lordship may kindly come to the recommendation. Now, my lord, before coming to recommendation, my lord, may I draw your lordship attention to page 381. There was a legal opinion. 381, my lord, clause D. Such legal opinion was appeared to be treated as comments, and accordingly, Professor Nonigopal Mohanta, the then registrar in charge Gauhati University, sent a communication dated 18/1/2019 to the Joint Secretary Government of Assam Higher Education Department, enclosing the above opinion by way of comments. So, my lord, a comments was given. Comments your lordship will find that, my lord, 382. Comments of Gauhati University on draft para in CAG's audit report on unapproved courses offered by the IDOL Gauhati University. That is the stand, my lord, of the university at that point of time. The Institute of Distance and Open Learning was established in the year 1998 under the name and style of the Postgraduate Correspondence School of Gauhati University. The institute got its present name in the year 2008. The competent authority regulating the affairs of the higher education through the open distance mode in the year 2007-8 was the Distance Education Council, Indira Gandhi National Open University. The institute submitted an application before the said authority requesting for recognition of courses offered by IDOL. Responding to the same, DEC IGNO by its letter dated 31-8-2007 granted provisional recognition for offering programs which are approved by the statutory bodies of the university. Your Lordship will kindly see, statutory bodies of the university means the academic council and the executive council. Granted provisional recognition of offering programs which are approved by the statutory bodies of the university through distance mode for a period of 1 year up to 31-8-2008. It may be mentioned herein that at that point of time, the PGCSU was offering 18 courses in the distance mode. The IDOL GU thereafter had submitted an application before the DEC IGNO for recognition of its program for 2008-9 onwards. In the response to the same, DEC IGNO by letter dated 9/6/2009 informed that the chairman of the DEC IGNO had constituted an expert committee to visit the university to evaluate the infrastructure, etc. of the university. The committee visited the university on 15/9/2009, but the report of the said committee was not made available to the university. Subsequently, the DEC IGNO by letter dated 17/12/2009 granted continuation of the earlier provisional recognition till expert committee submitted its recommendation, and a decision was taken by the joint committee regarding grant of regular recognition to the university. Therefore, the meaning and purport of the letter dated 17/12/2009 was that all courses offered by PGCS IDOL GU which were approved by the statutory bodies, that is the academic council of the university, were granted provisional recognition by DEC IGNO till the regular recognition is granted. This is the stand of the, my lord, university. And now, my lord, they want to blame me. The DEC IGNO by letter dated 4/8/2010 informed the university that the Distance Education Council in its 35 meeting had decided to accord recognition to the university for a period of 3 years for the academic years 2010-11 to 2012-13 for offering 8 courses in the distance education mode. This gave rise to a slightly anomalous situation in as much as all the courses which had been granted provisional recognition by letter dated 31/8/2007 and continued by letter dated 17/12/2009, except the 8 courses mentioned in the letter dated 4/8/2010 were suddenly discontinued, much to the detriment of the students as well as the university. Several correspondences were made by the university GU to accord recognition to the various courses which were left out in the letter dated 4/8/2010. The GU bona fide believes that the DEC IGNO would give recognition to the other courses which had been left out, as according to IDOL's view, it was an inadvertent error on the part of the authorities concerned. The UGC took over the regulatory function of the open and distance learning with effect from June 2013 and by letter dated 21/1/2014 granted continuance of the recognition of the IDOL's view for an academic year 2013-14. It was specifically mentioned therein that such recognition was in continuation of the letter dated 4/8/2010. It is also pertinent to mention here that the UGC continued the recognition of the 8 courses, while later dated so-and-so university has been granted approval recognition for 20 courses with effect from the academic year 2018-19, which have been detailed in the letter dated 14/8/2018. From the aforesaid, it is seen that with effect from 31/8/2007, provisional recognition was given to all courses of the Gauhati University to offer such courses in the distance education mode, and such provisional recognition continued till 3/8/2010. On 4/8/2010, recognition was accorded to 8 courses, and the authorities of the IDOL GU bona fide believe that the courses which were left out in the letter dated 4/8/2010 was due to some inadvertent mistake, and the same would be recognized in due course of time. And on such anticipation that the recognition would be granted, the authorities had continued to offer the 8 courses in distance education mode. However, the same have been discontinued, which happens so and so. The last paragraph. Any fee collected has gone to the account of the university sorry, my lord. On such anticipation that the recognition will be granted, the authorities had continued to offer the same courses in the distance education mode. However, the same have been discontinued with effect from academic year 2017-18. Further, till date, no complaint or case has been filed by any student who had undergone such courses and alleging that the courses offered has not been recognized by any of the employer or that any organization has refused to recognize the said courses, meaning thereby that all such courses have been duly recognized by the university employees authorities. Any fee collected gone to the university and there is no personal involvement of anyone. It is respectfully stated that it was a bona fide error of judgment on the part of the authorities of Idol GU and there was no ill mention on anybody's part. So, my lord, the university, the registrar says that it is an bona fide error of judgment. Therefore, my lord, I will rely on the decision. I have already placed, my lord, and will read that, my lord, error of judgment cannot be a misconduct. That I will place, my lord. So, it is the university stand before the, my lord, commission. Now, the recommendation. If your lordship kindly comes to page 419, 419, issues have been framed. Issues your lordship will kindly write, my lord. The following 12 issues have been framed. Number one, whether GU Idol had run exactly 21 unapproved courses during the period 2010 to 17 as observed in CAG report. Number two, whether the continuation of the alleged 21 approved courses was within the knowledge of the then directors. Your lordship will kindly notice the S. Plural, directors of GU Idol and other authorities of the GU during the period 2010 to 17. Then three, whether the approval from DEC UGC was necessary to run those unapproved courses and if yes, whether any appropriate steps was taken by the directors of the GU Idol. Now, the findings your lordship will find at 437. Clause 137. In view of the deductions and observations above, has your lordship got it, my lord? In view of the deductions and observations above, the commission is of the view that GU Idol had run offered courses not being approved by the DEC UGC during the relevant period. The number of unapproved courses so run would, as apparent on the face of the records, be 23 instead of 21. This is one finding. Then, my lord, for other issues, your lordship may turn to page 439. These are the, my lord, issues that have been framed. My lord, your lordship may skip this and come to page 442, clause 147.
Page number?
Page 442.
442.
My lord, 442, clause 147. While deposing before the commission, CW 11, Professor P.J. Das was the, my lord, next director. P.J. Das told that any PG diploma course to be run by the Idol should be placed before the advisory board of the GU Idol, and thereafter the same was sent to the AC, Academic Council, for discussion and approval. Once it was approved by AC, it would be submitted before the EC, Executive Council, for final approval. Then it was sent to DEC UGC for its recognition, and only on getting recognition from DEC UGC, the course could be offered by GU Idol through ODL mode. He further stated that VC, being the head of the institution, should be in total control of all affairs of the GU. Registrar was the administrative head, and nothing should be moved without the knowledge of both VC and registrar. So everybody knew about it. The subsequent director has also made this statement before the Justice Saikia Commission. Now, findings, Your Lordship will find at page 444. Clause 153. Having examined, discussed, and stated as above, the commission opines that, my lord, I pause here for a while. I am not reading, my lord, the other statements made by many persons, because, my lord, some will speak in my favor, some will speak against me. So it is ultimately the finding, my lord, which has been arrived at by the Honorable Commission. Number one, the continuation of alleged unapproved courses was within the knowledge of the then VC, GU, Director of GU Idol, and registrars of GU served during the period 2010 to 17. This is a clear finding, my lord. The steps taken by the Director GU Idol in continuing the unapproved courses in GU Idol, despite non-approval of the same by the DEC, UGC, were not justified, and the action of the then VCs, GU, Director of GU Idol, and Registrar GU in continuing the unapproved courses during the period 2010 to 17 were also not justified. So, my lord, here the Vice Chancellors, the Directors, and the Registrars have been, my lord, indicted. As such, all of them appear to be responsible. Now, my lord, they initiate proceeding against me alone. Then, my lord, the other finding I'd like to draw your lordship's attention, your lordship will find at page 449. Clause 164.
Yes.
In terms of the discussions and observations made herein above, the Commission is of the firm view that the approval of DEC UGC was essential to run those unapproved courses as alleged in the CAD report. However, the then directors ought to have taken appropriate measures to get the approval from the UGC until such time no such courses should have been run in anticipation of recognition. That being the position, it appears that no appropriate steps were taken by the directors, EU Idol. So, my lord, these are the findings. And my lord, recommendations, your lordship will find at page 467.
Yes.
203. Number one, GU authorities may approach the state government for initiating appropriate action against the VCs of GU serving during 2010-17, being found responsible in terms of the issue-wise findings recorded in the report, my lord. Where is that action, my lord? The university in their affidavit and in their submission, my lord, they are silent on this. I am a soft target for them to save the others. And when, my lord, I am not the decision-making authority. So that was one of the recommendations, my lord. So far as this recommendation is concerned, my lord, nothing has been done against the VCs and the registrars and, my lord, other directors who were prior to me running unapproved courses and subsequent to me running unapproved courses. No proceeding has been initiated against them. Another document will, my lord, fortify my my submission that your lordship finds at page 482. Is it the one over there?
Page number?
Page 482, my lord.
482.
There, my lord, Distance Education Council of the Indira Gandhi National Open University, my lord, gave provisional recognition that was in, my lord, 31/8/2017. And, my lord, it was requested that fresh application should be developed and, my lord, should be submitted. Now, provisional recognition came, my lord, page 483. So it continued for, my lord, the subsequent 2 years. And there are subsequent communications, but one thing, my lord, I would like to point out at post 483, my lord, the signature of the registrar is there. Down below, before the seal, your lordship will find, my lord, the registrar has signed. So, my lord, they cannot feign ignorance of the fact that, my lord, this process was continuing and that was continued by the petitioner and also, my lord, other directors to get the, my lord, approval of the UGC and DEC. Some pages your lordship may like to read, my lord, note down and read the page 502. I'll not read, my lord. I want to save time of the honorable court, my lord. Page 502 will be relevant in the same context, my lord.
50?
502, my lord, that the petitioner has been taking steps for recognition. It's not that, my lord, he was, although, my lord, he didn't have any role in the academic council and executive council, he has been continuing with the, my lord, pursuing this matter. Page 502, your lordship will find. This is written by the petitioner to the Distance Education Council for recognition of the, my lord, courses. So he was pursuing the matter, my lord. There are other communications also, my lord. Page 505, there is another communication, my lord. I will not burden your lordship with all this, but it's not true to say that, my lord, he did not take any steps. These are on record, my lord. Now I'll, my lord, sum up now. I'll be very brief because the points that he has, my Mr. Saikia has urged, my lord. So your lordship has already noted down the dates, my lord, where when the inquiry officer, the petitioner, before, my lord, the charge sheet was issued on 8/6, perhaps, my lord, your lordship has already noted that, my lord. I'll not repeat that. 8/6/2021, EC decided to appoint the inquiry officer. Subsequently, DSI, my lord, this is only an offer letter, not an appointment. But the resolution was confirmed on 12/7/2021 and subsequently, my lord, 10/6/2021, EO was appointed and the charge sheet was issued on 22/6/2021. And this charge sheet was also not approved. So, my lord, since, my lord, I have already argued that, my lord, I will not take your lordship's time. Therefore, the charge sheet, and, my lord, there is nothing on record to show that, my lord, the charge sheet was placed before the executive council by the before the disciplinary authority. Now, my lord, now, my lord, one document I'd like to show. There is a, my lord, dissent note of my lord, one of the members, my lord. If your lordship kindly comes to my lord, compilation, although it's on record, my lord, this compilation, it will be easier to find out, my lord. At page 104A and 104B. How the, my lord, inquiry was proceeding. One 104A. This is a communication from Dr. Hemanta Kumar Sharma, who was a professor of the Department of Economics, and he was the, my lord, one of the members of the EC. Now, subject is justification of my note of dissent against acceptance of the report by ECGU, which was submitted by Mr. Pallab Bhattacharya to Gauhati University. May I read that, my lord? In the EC meeting of GU dated 20th September 2001, I argued verbally against the acceptance of the report by the ECGU and requested the authority to record my note of dissent against the decision of acceptance of the report by the EC, Gauhati University. Now I am sending my arguments in writing with request to you to assert in my note of dissent in the minutes of the proceedings of the said meeting. My arguments are as follows. Professor Kandrapadas, the petitioner, joined as Director IDOL in August 2006 and left the directorship of IDOL in January 2006. The present inquiry was held for finding and fixing responsibility for continuation of unapproved courses in IDOL during 2010 to 2017. Till now, there is no answer regarding who is responsible for continuation of unapproved courses for the time period between January 2016, when Professor Das left the director post, till 2017. I feel without finding out this, the inquiry will be incomplete and perverse. Number two, Professor Das joined as the director of IDOL on August 19, 2006. The PGCS used to run 14 subjects at that time. When the letter from DEC IGNO was received on 4/8/2010 by the then VC informing about the approval of the only 8 PG courses, IDOL was offering 28 courses at that time. When the letter from DEC IGNO was received on 4/8/2010 by the VC informing about the approval of only PG courses, IDOL was offering 24 courses at that time. After completion of the first term of 5 years in the position of Director IDOL starting from 2006, Professor Das was appointed for a second term by the GU authority. I feel the decision was taken looking at the efficiency, sincerity of Professor Kandrapadas. Before putting the blame entirely on Professor Kandrapadas as the director of the IDOL GU, the duties and responsibilities bestowed on him as the director should be looked into. While creating the post of the director of IDOL by the Executive Council in its meeting dated 29/10/2005 by the resolution number such and such was resolved that it will be manned by a full-time director in the rank of a professor. The meeting further resolved that the administrative and financial control of the PGCS will be under the Vice Chancellor. The above resolution clarified that the VC is duty-bound to know all the administrative and financial details of the institute. Moreover, had Professor Das not carried out the orders of the VC, he could have been charged with disobedience towards higher authority. Induction of new courses, admission to any of the courses of the IDOL GU is regulated by the statutory provisions of the Gauhati University Act. The same has been substantiated by a written statement by Dr. Midul Hazarika, former Vice Chancellor, to Mr. K.K. Sharma, Secretary, Department of Higher Education, Government of India, on 3/7/2017. Dr. Hazarika wrote, prior to and after obtaining institutional recognition, GU IDOL introduced several master degree courses and diploma program by following the established Gauhati University statutory procedure. A core committee or an advisory board was always there since its inception, in which VC was the chairman and the registrar, controller, and academic registrars, treasurer, etc., were other members of the committee of the board. Every action was carried out according to the resolutions taken in this committee or board. In this context, I'd like to cite one resolution of the core committee taken on 18/5/2009 when Professor Das was the director, and two more resolutions taken on 21/7/2016 and 23/11/2016 respectively. That is when Professor Das was no more the director of the IDOL. In the fourth resolution, 18/5/2009 of the core committee, when late Professor O.K. Medhi, the then Vice Chancellor, was on chair, the committee resolved as follows. The core committee resolved to introduce MA in Nepali from the next academic session. The core committee also resolved to introduce MCA, MSc IT, and MT from the academic session 2019 and accept the recommendation of the Management Committee for IT courses regarding the detailed fee structure and study center and fee sharing arrangement with study centers. Professor Kandrapadas was the director of IDOL GU at that time. In the second resolution of the advisory board meeting, when Dr. Midul Hazarika, the then Vice Chancellor, was on chair, the board resolved as follows. As the process of admission to different programs is getting delayed due to non-receipt of approval communication from the UGC DEB, the board resolved that admission to offered courses should start immediately for greater interest of the students. In the third resolution, it was resolved as follows. In case of any action of UGC DEB on matters of program offered by the GU Idol which might affect the future of the students seeking admission to GU Idol and or those already enrolled, as also the people of the state at large, the board authorizes the university to take appropriate measures of appeal to UGC DEB. Then these resolutions are adopted, keeping in view the future of the thousands of aspiring students and learners and the people of the state at large. It is noteworthy that during these resolutions and subsequent implementation of the resolutions, Professor Das was not the director, but the period is within the period of investigation. So the question remains is who will take the responsibility, and without answering to that qualification, the investigation is incomplete and perverse. Then, my lord, it's too long, my lord, your lordship. Paragraph 9, your lordship may then read, my lord. He has given all the instances, my lord, that the authorities who can take decision had taken decision to run the courses. 104D, my lord, clause 9. We are investigating a procedural lapse as confirmed by the EC committee, and I feel in the process we ourselves should not create other procedural lapses during the course of taking our final decision. As far my knowledge about the disciplinary procedure of Assam government, the charge sheet should be framed and approved by the disciplinary authority, in this case EC of GU, and served upon the charged officer, in case Dr. Das. After getting reply from the charged officer within a specified time, the disciplinary authority itself can investigate the same on the basis of charge sheet, and reply or can employ some inquiry officer and presenting officer to the same on behalf of the disciplinary authority. In the present case, the inquiry officer was employed on 10/6/2021, following the decision of the EC on 8/6/2021. That is much before the charges were framed, and served on the charged officer on 22/6/2021. Myself, as EC member, I have not seen that either the charges were framed by the EC or even it was approved by the EC. The above procedural lapse is a serious one, and I feel it is a violation of principle of natural justice and Rule 9 of the rules. Under the above circumstances, I would like to appeal to the EC members to at least to go through the charge sheet. Then, my lord, this is his submission. Now, my lord, I don't, my lord, refer to. I am, my lord, trying to reply his contentions. One thing, my lord, it was argued that the petitioner before the inquiry officer made a statement that I have full confidence in you. Because, my lord, and therefore, my lord, he cannot go back and challenge the, my lord, the inquiry officer's report or the, my lord, subsequent officer. That is one of the submission. My lord, my reply to that will be, my lord, when the proceeding initiated, my lord, the petitioner giving a, my lord, expressing his confidence on him does not mean that, my lord, he will be instructed in law for, my lord, regime, because subsequently he understood that, my lord, it is only to, my lord, pin the, my lord, petitioner and leave the others. And, my lord, there is no estoppel against law, my lord. The law says that the matter has to be done in a particular manner, and that having not been done, my lord, I have placed other decisions with the written argument, my lord. I will not burden your lordship with that, but this decision is on that point, my lord. That I am additionally, I am, my lord, placing this because this argument was made by my learned friend, Mr. Saikia. This is on the point, my lord, that, my lord, there cannot be acquiescence or estoppel against law. Paragraph 23. No, it's not.
What is the relevant paragraph?
Paragraph 23, my lord.
23.
The case laws relied upon by division bench would have no application in the facts of the present case, and none of the judgments relied with the division bench laid down the principle of estoppel would be above law. It is separate principle that principle of estoppel cannot override the law. So my lord, the fact that at some point of time he said that I have full confidence on this inquiry officer does not mean that, my lord, he cannot challenge the entire procedure. Now, one more point only, my lord. I'll finish in 2 minutes, my lord, if your lordship permits. Here, my lord, the argument was that the inquiry officer, his, my lord, formal appointment was subsequent to the issuance of charge sheet. That is what my Mr. Saikia has submitted. Because, my lord, according to him, the letter of appointment was 1st of July 2021, and the earlier, my lord, communications, those are only offers. Those are only offers. That offer was made prior to issuance of charge sheet. That is an admitted position of law. But at the same time, my lord, in the PIL, my lord, there was a PIL. In the PIL, they had clearly stated a stand. If your lordship kindly comes to page 18, page 80, the judgment in the PIL, my lord. In this special book, my lord, page 80.
Where is that PIL?
Paper book. My given in the paper book, my lord, page 80.
Page number?
80.
80. Yes.
If your lordship, my lord, comes to page 84.
Yes.
This order has been passed because, my lord, date will be relevant, my lord. Order has been passed on 23rd of June 2021 in the PIL. Charge sheet was issued on 22nd of June. 1 day prior. Just 1 day prior to this judgment. Page 81, your lordship will find the date of the judgment, my lord.
Yes.
23/6/2021, your lordship has already noted down, my lord, the charge sheet was issued on 22/6/2021. And petitioner filed his reply on 28/6/2021. Now, my lord, if your lordship kindly comes to page 84. I'll read only 2 clauses, my lord. Clause 4 and 5 at page 84. To appoint one Sri Pallab Bhattacharya, IPS, retired, former chairman of the APSC, to draw the departmental proceedings against the Professor Kandapadas with the present register as the presenting officer thereof. So, my lord, this was informed to the court, and the court has recorded, my lord. Then clause 5. The relevant offer letter dated 10/6/2021 has been issued to the said Sri Pallab Bhattacharya, and he has been requested to complete the process within 1 month. Sri Bhattacharya has accepted the assignment and has already initiated the said proceeding. It is stated that the charge sheet has already been drawn against the Kandapadas and served upon him. One of the question is, when does a proceeding is initiated? Proceeding is initiated on, my lord, issuance of the charge sheet. Here, my lord, they say that already proceeding has been initiated and Bhattacharya has accepted the assignment. So, my lord, they take 2 different stands. As if, my lord, the Pallab Bhattacharya has, my lord, framed the charge sheet and he has initiated the proceeding. That is what is reflected in clause 5. Now, my lord, when I challenge this with all the, my lord, case laws in my support, then, my lord, they take a different stand here, my lord. That no, we appointed him later on. Formal appointment was later. But in the PIL, my lord, before this honorable court, before the division bench, they said that already proceeding has been initiated and Pallab Bhattacharya has already initiated the proceeding. On this point, my lord, the Rajasthan High Court decision, I will not argue now, my lord. The decisions your lordship will, my lord, kindly consider. This is, I conclude, my lord, if there is any query, my lord, I am ready to reply. Rajasthan High Court judgment that I have placed is basically on that point, my lord.
So you want to file a written argument?
My lord, in fact, a written argument has already been filed, but I can add the new case law, one case law only to that, my lord.
Okay. Okay.
May I? My lord, place it before the court master, my lord.
Heard Mr. M.K. Sharma, learned. Senior counsel assisted by Mr. Learned counsel for the petitioner. Mr. K.K. Gogoi was present here.
He came.
Okay. Mr. K.K. Gogoi for the respondent number
125.
25 and Mr. Fukun for respondent number. Argument concluded, judgment reserved.
I'm grateful for giving me a patient hearing, my lord.
Turning item 21 and 22.
Yes.
In which pattern the pleadings are always completed. The pleadings are completed.
Pleadings completed.
But the department has requested the landlord easy to appear. But you can take up tomorrow.
Tomorrow.
Because we have filed our affidavit, they have filed the reply today. They want
Okay. So perhaps here notice was not issued. Today let notice go. Tomorrow.
And then I'll suggest request for 12th of August.
12th of?
August. Oh, sorry, 12th of March. Sorry.
No. So urgency is there, perhaps.
Yes, urgency is there, my lord.
Tomorrow. Heard. Mr. Mandal, learned counsel for the petitioner, and R. Islam for the petitioner in WPC number 6997 of 2025. Mr. Kosik, learned standing counsel for the respondent in Elementary Education Department, submits that in this matter, pleading has been completed, and the matter may be listed for admission hearing. However, it appears that notice has not been issued till date. Accordingly, it is provided that notice be issued to the respondents, returnable by tomorrow. Since Mr. Kosik entered appearance and received notice for all the respondents, no formal notice is required to be issued to him. Is the matter tomorrow? At what time you specify one time?
10 yeah.
As first item or at 2 p.m. or whatever you like?
Not let it be the first half.
First half. 10:30. 10:30. List the matter tomorrow as item number 1.
Development.
I'm referring for the respondent. Is the issue is very small issue. And perhaps the lordship may dispose it of with direction.
Today it is in the order column.
Just only, it's a very small issue. There, we have filed a title execution proceeding. Prior to. It's a landlord tenancy dispute. Landlord tenancy dispute. I got a decree in my favor. I filed execution proceeding. The defendant filed title appeal. There some modification in the rent amount has been done. After that, in the meantime, we have filed the title execution proceeding. After that, they also lost in title appeal. They filed civil division petition. That also got dismissed. They did not appear in the title execution proceeding, and the court, executing court, issued a writ for some amount. Against that order, they have come. Against the writ, basically, they have come in this revision petition. So my only submission is whether this High Court can decide the quantum or what should be the amount in the decretal amount that they should approach before the executing court, not before the High Court. So their prayer, I am, the Lordship may allow their prayer. Page 17. Prayer number 4. That's the only thing. Since they did not appear before the executing court issued the writ. Now they have, it's within their knowledge, let them approach before the executing court, according to them, what amount should be payable to the landlord. Executing court will decide. That much of it.
So this pair we can allow.
Yes.
Lordship, the amount was varying because in title suit, the decree in the title suit, the amount changed and then we appealed. The amount was modified, the rent quantum. We vacated the premises on November 2023. But the amount against which the writ was issued, it was according to the, so far our contention is that it was according to the title suits decree. But it ought to have been according to title appeals decree. There was modification in the quantum.
Is it?
What I'm saying.
Is it?
Yes.
Okay.
That's what I'm saying.
That
They
is
should
the
approach
issue.
the executing court.
We have approached that. We have filed a petition. We have annexed the application. We have filed a
Right,
petition.
Coming to High Court, they have filed the petition. After that, they didn't appear. And you see the order, which is spelled in page 71. They did not even appear in the executing petition after filing that application. Let them approach the executing court and say whatever they want to say.
Also, because the writ, in the writ mechanically, it was written as execution of the decree in past in title appeal number. It was mentioned as title appeal, but the amount was not changed.
Page 71, order, and page
73 is the.
writ.
Okay, yes.
So their prayer, I am considering, let them approach before the executing court, and the executing court will decide.
Also, the matter will
That's what-
relate there only. Because
Prayer for, the prayer for may be granted, nothing else. Execution
the prayer
cannot be
for is
caused.
the decree on, is the relief which we are seeking only. The amount would be according to title appeal.
Yes.
Okay. Okay. Heard, Mr.
T. Majumdar for the petitioner. T. Majumdar.
T. Mazumdar, learned counsel for the petitioner. And Mr. Edhor, learned counsel for the respondent. In this petition under Article 227 of the Constitution of India, read with Section 115 of the Code of Civil Procedure, the petitioner has right for the petitioner has challenged the order dated.
What should we have challenged the writ?
Challenge the
Order. We have challenged
Challenge the
writ.
Rate,
Writ.
only read.
Writ.
is it permissible?
The amount was varying, that's why, and according to the.
No,
prayer-
though directly they have not mentioned about the order yet. The writ was issued pursuant to an order. So impliedly it is the order by which the writ was issued.
It's a direction to the bailiff.
Yes. Challenge the order dated 5/6/2025. Where it is mentioned?
73 page.
Page number
73.
73. Okay. Challenge the rate. Challenge the rate dated 5/6/2025 issued pursuant to the order dated 28/8/25. Page number 71.
Lordship, there is no mention of the rate here.
That is not
Mentioned in the rate.
The by which order the writ was issued?
That is not annexed.
Hmm? Okay, we'll pass the order in the different manner. The petitioner has instituted this civil revision petition praying for following reliefs. Number one, call for record of title execution case number 11 of 2022 pending before the Court of Learned Civil Justice for. Number two, set aside the notice to the bailiff with an inverted comma read dated 5/6/2025 passed by the Learned Civil Judge Senior Division Sonitpur. Comma test for in title execution case number 11 of 2022. Number three, set aside and quash the proceeding of the title execution case number 11 of 2022 on the basis of the trial court decree dated 31/5/2022 in the title suit number 5 of 2018. Number four, direct the executing court to execute the decree strictly in terms of the appellate decree dated 3/5/2023 passed in title appeal number 1 of 2022 passed by the Learned District Judge Sonitpur at Tazpur. On the application filed by the respondent. The Learned Counsel for the petitioner submits that the petitioner is aggrieved for issuance of the writ dated 3/5/2020, dated 5/6/2025 for execution of the decree dated 31/5/2022 passed in title suit number 5 of 2018. He further submits that after the decree dated 31/5/2022 being passed in title suit number 5 of 2018, the petitioner herein, you have preferred the appeal.
We have
The
preferred that.
petitioner has preferred an appeal being title appeal number 1 of 2022 before the Learned District Judge, and the Learned District Judge filed
Decree dated
decree dated 3/5/2023 has affirmed the decree so passed by the Learned Trial Court. However, modified the decretal amount from rupees
Not rupees. From 11,000 from 12/7/2017.
where it is mentioned
Page number 58.
Page number
58.
58.
Which line?
The full.
So the respondent plaintiff is entitled, last line, entitled to rent at the rate of 11,000 per month only from 12/7/2017.
Okay. To the extent that the plaintiff respondent is entitled to rent with effect from 12/7/2017 at the rate of rupees 11,000.
Per month.
11,000. 11,000 per month. And the rate was issued for recovery of
12 lakhs 36,000.
at the rate of 12,000.
No, madam,
No.
that is not mentioned.
Okay.
That will be decided by the executing court. The amount.
Okay. However, the trial court has issued the rate for recovery of the amount as per the judgment and decree. As per the decree passed by the learned trial court. Trial court.
It's their contention.
Yes. The learned counsel for the petitioner further submits that the petitioner has filed an application. Where is that application?
Page number 64.
64. 64 before the learned executing court. Before the learned executing court. In title execution case number 11 of 2022, which was registered pursuant to the judgment and decree passed by the learned appellate court. Appellate court. And since the amount has been modified by the learned appellate court in the decree passed on 3/5/2023, the rate ought to have been issued to execute the aforementioned decree dated 3/5/2023. At this instance, Mr. Dhor, learned counsel for the respondent, submits that the respondents herein concede to the pair at serial number 4 of the petition. And as such, this matter may be disposed of, directing the learned executing court to consider the application dated 14/7/2025.
23.
23. Oh, why you have not pursued this application?
Worship, they filed it, and in the writ also, the writ was also mentioned as title appeal 01/22. But the amount, I don't know for what reason the amount varied.
They have not pursued this application. Then it is reflected in the order also.
However, the application could not be pursued before the trial court, no executing court. The learned counsel for the petitioner also submits that this matter may be disposed of by remanding the matter to the learned executing court to consider the application dated 14/7/2023 filed by the petitioner, and thereafter to proceed with the execution case in accordance with law. But having heard the submission of learned counsel for both the parties, this court has carefully gone through the petition and the documents placed on record. And also peruse the rate dated 5/6/2025 issued by the learned executing court. Taking note of the submission of learned counsel for both the parties, and also considering the facts and circumstances on the record, this court is inclined to dispose of this petition by directing the learned trial court to dispose of the application that is so filed by the petitioner before it, and thereafter to proceed with the execution case in accordance with law.
Parties will appear before the executing court.
Yes,
At the state.
both the parties are directed to appear before the learned executing court on or before? When?
This 27 February.
27 February. Yes, would it be convenient to you?
Not Saturday, maybe, or
It's not Saturday. Friday.
okay.
Friday, okay.
But just one observation, if the judgment doesn't appear, then the executive court will proceed accordingly. Because the judgment debtor was not appearing since last 3 years. In that
No,
condition.
the trial court, no, executing court will proceed in accordance
Accordance
with
with
law.
law.
If he does not appear, then okay.
Appellant appeal.
Why such observation is necessary?
There was not executing part is the most difficult part.
Yes, a difficult part.
Number 12.
So kindly pass the body matter for the time being.
We does not have mass matter. We'll wind up shortly.
Let it be last item. Mr. Das is lex on. He was on lex in court number 21. Let the matter be last item.
When? Heard, Mr.
D. Burua.
Learned
One
counsel
POV
for
suggestions.
the appellant and Mr. Arsipal, learned counsel for the respondent number. What? Mr. Pal submits that he has some difficulties today to argue the matter.
But not last.
Accordingly, it is provided that recessal is the matter on.
Item 13.
May please, Lordship, in this case, my lord, I file an IA for re-implement. That IA, because I could not serve because my landed pen was out of station. So today he has received. That is not in the record. So my lord, this is my copy, my lord.
IA is not before this court.
I mean, my lord, they have voluntarily struck out the name of the driver and the owner, my lord. No, I have written, my lord, all those things.
Thereafter,
Because I'll argue this. I'll
reinserted, my lord.
Because that time, my lord, the 3 cases also registered, before the,
Heard, Mr. Arsipal.
My lord,
learned
this is
counsel for
the-
the appellant and Mr. Bhuya for the respondent number.
this is the number, my lord.
One, respondent number 1. Mr. Pal submits that he has filed one interlocutory application
sir.
for implement of driver and owner.
Yeah, respondent
Driver
number 2 and
and
3.
owner as respondent number
2 and 3.
2 and 3. But the same has not been listed before this court today, and accordingly, he submits that the matter may be listed in the next week, along with the I. They are allowed recessal is the matter on
24th February.
24th February.
I thought 20.
My lord, not 24, my lord. If it is 26, 26, my lord, Thursday. My lord,
Item 20.
my lord, February,
Oh, okay.
26, man. Much obliged.
Lordship, today the conducted counsel having some personal difficulty, your lordship.
Who is the conducting counsel?
H. Agarwal.
Okay.
Lordship,
Art-
fix the date in the month of March, Lordship.
Heard, Mr. Sharma, learned counsel for the appellant and Miss
M. Somatwe, I'll write down my name.
learned counsel appearing on behalf of Mr. S. Agora.
H. Agarwal, yes, your lordship.
H. Agora.
H. Agarwal.
H. Agora. The learned counsel submits that the conducting counsel has some difficulties today and press for listening the matter. After 2 weeks,
No, Lordship, in the month of March, after 6th of March.
24th no.
24. Obliged.